viewers, and welcome back to India Roundup. The Real Estate Regulation Act, popularly known as RERA, has been getting a lot of attention from home buyers and investors alike within the country and outside India. Today, we bring to you the third and a final episode with Mr. Prabhakar, an expert in the field. I'm sure you will enjoy this. Mr. Prabhakar, this I think is very important. Can the registration be revoked by RERA? It's a serious matter, and if indeed that happens, the registration is revoked, how will the interests of the allotees be protected?
In case of an inordinate delay in completion of the project or non-compliance with the provisions of RERA, RERA has an authority and power to revoke the registration granted to a builder. But when this power has been exercised and the registration is revoked, the RERA has to make sure that they make the sufficient arrangements for completion of the incomplete project, either through an appropriate government or through the association of allotees. And in this case, as per section 8, first right of refusal is given to association of allotees if they have the capability to complete the project.
Sir, is there an obligation on the part of the builder to provide maintenance to the project after its completion?
This is an important thing for the allotees. Builder is under an obligation to maintain the project for 5 years from the date of issue of occupancy certificate. But yes, he has a right to collect maintenance charges from the flat buyers. But having said that, within this 5 years also, if the association wants, they can form their own maintenance agency or give it to some outsider and take it over from the builder. That means within 5 years also, if the allotees don't want the builder to maintain the society, then the builder has to hand over. Beyond 5 years, the builder is not under an obligation to do the maintenance of the project. But normally builders have their own agencies, and an agreement is entered into between the association of the allotees and the builders for maintenance. But it's only an optional thing, not a mandatory thing beyond 5 years.
Mr. Prabhakar, is there any remedy available to the buyer if he finds defects in the flat after he takes possession of the flat?
This is very important for the allotees to know that at the time of taking of possession, normally the allotees sign various documents, including an undertaking stating that they have done the inspection of the flat and found everything to be in order. Despite of the fact of this certificate being given, if the allotee finds any defect in structural of the building or workmanship or services to be provided at any time within 5 years of taking of possession of the flat, then the builder is under an obligation to rectify those defects within a period of 30 days of it being brought to his notice without charging any extra amount. So all the allotees should note and take advantage of this provision of RERA.
Welcome to Bengal, the sweetest part of India.
Mr. Prabhakar, under what conditions can a flat buyer seek refund of money paid? Can RERA order refund of the money paid by a flat buyer? If yes, with how much interest?
There are two circumstances under which a flat buyer can cancel his booking. One is on his own volition, that he doesn't want to continue with the project, and he can make an application seeking a refund of the money deposited by him by cancelling his booking. In that case, builder has to refund the money after deducting the booking amount which is mentioned in the agreement. Apart from that, if there is any delay in completion of the project, the allottee has two options: either seek a refund by cancelling the booking, or continue with the project and claim compensation. But in any case, whenever the booking is cancelled, the allottee has to bear the cost of registration and cost of stamp duty that has been paid, and also the government taxes which are not adjusted by the builder.
I'd like to know, Mr. Prabhakar, if due to a change in government policy, the developer becomes entitled to additional FSI, etc., can the developer build additional floors in an already registered ongoing project?
Yes, if there is any change in the policy of the government, and if the government allots any additional FSI, the builder can take advantage of that. But in case of a project which has already been registered, any such additions will be deemed to be alteration of the approved plans. So whenever such things happen, he has to take the prior consent of not less than 2/3 of the allottees to avail the additional FSI that may be granted to him. If the allottees don't give permission by a majority of 2/3, then the builder cannot go ahead with construction of additional space.
Sometimes in India, things take unduly long to be resolved. Is there any time limit prescribed for disposal of complaints under RERA?
RERA has provided for the speedy disposal of the complaints that are filed with RERA or appellate authority. As per the provisions of RERA, any complaint which has been filed with RERA or RERA appellate authority has to be disposed of within a period of 60 days, and if it is not disposed of within 60 days, the reasons for the same has to be recorded in the orders.
The most fascinating water world on earth, the Great Backwaters, Kerala.
And what is the appeal mechanism prescribed on orders given by RERA?
There is a well-laid appeal mechanism under RERA. An order of the RERA is appealable within a period of 60 days with the appellate authority, and an appeal against appellate authority lies with High Court. That too has to be done within 60 days of receiving of the order, and of course the orders of the High Court are appealable with the Supreme Court of India. But in case of a builder, when an order of paying of a compensation or a penalty is levied, then before making an appeal, he has to deposit 30% of the penalty amount or such amount as may be ordered by RERA before he can make an appeal. In case of a flat buyer, there is no such requirement while making an appeal.
Can RERA attach a project?
As of now, RERA doesn't have any authority to attach the properties of a builder. In some of the orders, the RERA has given order to attach the special account maintained by the builder, wherein 70% of the proceeds are to be deposited to be used only for the purpose of construction. Barring that, the attachment powers are not there as far as attaching other properties are concerned. Having said that, the RERA in its order which is given under section 40 can always give direction to the Metropolitan Magistrate or the revenue officers to recover the amount by way of attachment also, but it doesn't have a direct attachment pass.
Sir, does RERA have execution powers on the orders passed by them?
If a promoter, allottee or a broker fails to pay a penalty or interest that has been levied upon them, then the same can be recovered as land revenue arrears. But RERA doesn't have a direct power to execute its order. Whenever it gives an order and if it is not complied with, applicant can make an application under section 40 and the RERA can issue a recovery certificate, and that recovery certificate is to be taken to the revenue officers to get the same executed through them. So that is the execution mechanism as far as RERA is concerned.
Mr. Prabhakar, I think this is a very, very important one. Under RERA, are celebrities who act as brand ambassadors, are they made responsible in any way?
Yes, in India, the celebrities like film stars, cricketers, models, they make large amounts of money by being brand ambassadors. And apart from many other things, nowadays these celebrities are brand ambassadors for real estate projects also. But unfortunately, under RERA or under any other act in India, the brand ambassadors are not accountable or liable or responsible under the provisions of any act. So it is high time the government wakes up and puts some act whereby the brand ambassadors, the celebrities are made accountable for the tolls and sometimes maybe even false claims which are made without doing any due diligence. I understand in Western countries, a lot of celebrities like basketball players, tennis players and other players get a lot of due diligence done before endorsing and especially making any statements or claims about a product. And it's high time we should have that in India as well.
Mr. Prabhakar, I'd like to sincerely thank you. I think this has been a very interesting discussion. We have learned a great deal from your experience. Many thanks.